Hi, welcome to another edition of IP Somm. I'm Heather Boyd, owner and proprietor of Pillar IP, and my guest today for IP Around the World is Lina. Is that
Yes.
correct? Yeah, from
Correct.
IP March
March.
in Beijing.
Yes.
And we're going to talk about the differences in the trademark registration process between Canada and China. So I'm hoping you enjoy this. Lina, why don't you tell us a little bit about yourself, how long you've been in practice, and about your company, please?
I joined this profession in 27, so it has been 13 years. And I joined IP March in 2017, which is 5 years ago. And we are an IP boutique firm. We focus mainly on patent, trademark, copyright, and domain name, those IP-related matters.
So you are a partner with your firm?
Yes, I'm a partner on
And
trademark side.
have you been a partner since you joined the firm?
Yes.
Excellent. Okay. Well, thank you. Congratulations. That's awesome. There's so many differences between the Canadian and the Chinese registration process. Now, one of the things that my clients have always kind of grappled with is the fact that every Chinese associate recommends that they have to use a Chinese name to file their applications. Can you explain the reasoning behind that?
Okay. Mm-hmm. For Chinese people, Chinese trademarks, which means trademarks in Chinese characters, will be easier for them to pronounce and remember.
Mm-hmm.
Because even the very well educated, English educated Chinese people, they are not used to pronounce or call a trademark in English. For example, Coca-Cola in China, seldom of the Chinese people will say Coca-Cola. They will call it 可口可乐, which is a Chinese trademark.
Okay.
So because of the cultural reasons, it's quite recommended to choose an equivalent Chinese trademark, which means the mark in Chinese characters.
Okay, so going through that, from my understanding, the either Cantonese or Mandarin languages, they're very visual. Is that my understanding? So when it's a trademark, you want to create a picture kind of thing or a visual expression of that word in Cantonese or Mandarin. So that's why they recommend changing it to Cantonese or Mandarin because it's more of an expressive language. Is that?
Yes, yes. For example, BMW, its Chinese mark is 宝马, which means very treasured horse.
Oh, a very treasured horse? That makes sense.
In Chinese history, 宝马, they can run very fast.
Okay.
They are very high qualified or very treasured horses. So I think the translation is very excellent.
Yeah.
And the Chinese trademark is even expressing even more meaning than the English trademark to Chinese consumers.
So it makes more sense to do that. Now, how do you come up with it? Like, do you do the translations yourself for when you're presented with an English trademark?
Yes, we usually do the translation by ourselves because for some trademark, it's better to use their equivalent translation. But for some trademark, if the translation is not that good as a trademark or cannot be registered according to Chinese trademark law, we usually will use transliteration, which means use the similar pronunciation of the English mark. When we conduct such kind of, or when we were selecting such kind of trademark, we'll conduct a similarity search through the CNIPA's online database so that our recommendation will make more sense from the registration perspective.
Okay, so you don't recommend a direct transliteration of the company's name or the company's trademark. in certain instances. Can you give us examples of that?
I remember we used to have a client whose trademark um, heritage. Because, for example, the English mark is heritage, but when you make the equivalent Chinese translation, it may not be that good, especially for some classes. The examiners may consider it lacks of distinctiveness
Okay.
and may refuse the registration. And for some English trademark, the meaning maybe is not that positive, but people like that. If you use the equivalent Chinese translation, the examiners may consider that the meaning is not that positive. It may bring bad effect to the consumers or the public, so they may refuse such kind of trademark application. And
So,
that
so
circumstance,
maybe what we should
yeah.
do is go through what makes a trademark registrable in China.
Mm-hmm,
Because I mean, we obviously don't have any of these issues in Canada.
mm-hmm,
We have what we call as reciprocity rights between French and English. So if you
mm-hmm,
file for a trademark in English, then automatically you should be protected against the direct translation in French. Now, obviously, there could be maybe multiple translations. So you have to pick one, and that's the only one you get to go with, kind of thing. And you would still have to go through a case where you would have to prove that people would
mm-hmm,
recognize or translate it to the English side of that. But it
mm-hmm,
doesn't there. I don't think there's any, unless it's the actual name of the goods or services, which we cover off both French or English in that case.
mm-hmm,
Then or it's descriptive of the goods and services in French or English, then it's not registrable. If it's the
mm-hmm,
name of the specific goods or services in any language, it's also not registrable. So
mm-hmm.
yeah. So maybe you can tell me is the trademarks office examining the CNIPA? What are they examining an application for registrability?
Mm-hmm. Um, the first, according to the Chinese trademark law, trademarks that are identical with or similar to some special words such as the state name, the state flag, or things like that cannot be registered or even used. Such kind of mark are not allowed to be used in China.
Right. We
And
have
for
the equivalent in Canada. They're called official marks. And it's just that
mm-hmm,
they don't want to have the appearance of being approved by the government or the crown,
yes,
because we're part of the Commonwealth. So
mm-hmm.
yeah.
And for trademarks, if they are lack of distinctiveness, then it will be refused. They are not allowed to be registered. But if you can prove that the mark has obtained its distinctiveness through use, then it may be registered. And
So you
also,
can Sorry, I
mhm,
was going to say, so you can prove that it's distinctive through
mhm,
use, right? So there
use,
have to have been
yes,
use for that. And is it
yes,
widespread use that throughout China, or is it just in one area that is sufficient for that?
it should be in China, yeah, through China,
But
not
all of
in
China, because we have that in Canada, they say that it
mhm,
has to have acquired distinctiveness throughout all the
mhm,
provinces or the greater majority of the populated
mhm,
provinces. So
mhm.
yeah.
Yes, it should be to most of the Chinese consumers.
Okay. And how do you
Mhm.
prove that?
It's very complicated. You need to you need to prove that the mark has been used for example, a long period of time, maybe several years at least, and then in a wide scope of cities or provinces in China.
Okay.
And then the mark has achieved a certain degree of influence, which means that when a common Chinese consumer saw this mark, they will recognize it's the trademark for a certain goods rather than a descriptive word.
Right. So what we do is we call it, it's achieved what we call a secondary meaning.
Yes,
So
yes,
yeah.
exactly the same. Yeah.
And I think in Canada, it's pretty much the same. I mean, the scope has to be fairly widespread. It
Yes.
normally has to be for several years, or it has to have achieved a notoriety within a short period of time based on how much money they've either spent
Yeah.
to
Yes.
advertise it such that it's
Mm-hmm.
become recognizable, or
Mm-hmm.
that they've made in the from the purchasing public. So
Mm-hmm.
is that similar in China as well? Like if it was only used for a year, but everybody bought
Mm-hmm.
the product and they can prove
Mm-hmm.
that they've made a ton of money off of
Mm-hmm.
this trademark, is that something that would be sufficient for proving distinctiveness?
That may happen, but the mark should be very famous.
Okay.
It can be recognized by almost every Chinese consumer or most of the Chinese consumer, but it's very rare. It's very rare. Usually, they will require the mark being used for a long period of time.
Okay.
Mhm.
Um, can you file multi-class applications in China?
Yes, yes. Multi-class applications are acceptable, but there are obvious disadvantages for filing trademark application in multi-class way,
So tell
which
us what
means,
those disadvantages are.
yeah, right now you can file in China either in multi-class way or single-class way. But if the trademark application is filed in multi-class way, when the trademark application is provisionally refused by the CNIPA in part of the classes or part of the goods, the trademark can be divided just between the provisionally refused part and the preliminary approved part.
Right.
Other division is not allowed. So that means if the trademark is opposed just in some classes, part of the classes, then the whole application, even in those uninvolved classes, need to wait for the opposition result, which means they cannot be registered first.
Okay, so
And
just so I can get this clear in my brain, if I filed for an application in class, let's say 25 and 28, so we're talking
mhm,
clothing and toys for people who
mhm,
don't know what classes are.
mhm,
If I list some of the classes in 28, which I know is based on subclasses, and we'll get into that, it can be,
mhm,
you can have some goods approved and others
mhm,
not. Um,
mhm.
for the mark, but the class 25 goods say are approved outright. Does the entire application fail until the class 28 unapproved goods can be either removed, or can you even remove them from the application?
Yes, you can remove them, but if you like the opposition proceeding is going on, then the other, let's say class 25, will be pending
Okay,
until
so it
it,
waits
it
until the opposition.
yes,
I mean,
yes,
we have
yeah.
that same thing here in Canada as well.
Uh-huh.
But so can you divide out the class 25
No,
uh, class? No? Okay.
no, no. And especially if a mark is registered in multi-classes, if you want to assign the mark just in part of the classes or renew just part of the classes, it's not allowed. You will need you will need to either assign the whole mark in all the classes or renew the mark in all the classes or just, you
Let it
know,
go and start
yeah.
again. Okay.
Yeah.
So
So
there's a
that's
definite difference between Canada and China in that respect, because you can at any time delete
mhm,
goods or services. You can never broaden the scope of protection of the
mhm,
application,
mhm,
but you
mhm,
can at any time delete a class or delete specific goods if you're not
mhm,
using them anymore for renewal. And
mhm,
you can assign specific classes to other people, I believe, but you risk dilution of the mark if it's an identical mark owned by two separate companies and those classes are considered related, you risk dilution of the mark. So, but that's very interesting. We can, in the face of an opposition, divide an application and proceed to registration based on the classes that have been approved and are not opposed. And then the other application is maintained with until the opposition results are finished. So that's a really good difference between the two. So thank you for that. Now, what else are so distinctiveness you're examining on? Can you talk a little bit about the subclassification system in China? Because this is something that's completely foreign to most other countries.
The subclass is a unique thing in China, I think. That's why most of the foreign clients, they don't understand why the two same trademark has coexisted in the same class. The reason is the subclasses we use. For example, in class 7, we have 54 subclasses, and in class 25, we have 13 subclasses. And I can give you some example.
Yeah, that would be lovely.
Let's say clothing, such as clothing, it being classified into subclasses 2501, 2502, 2503, 2504, and 2505. So, I mean, if you designate clothing in your trademark application, which means you can cover these 5 subclasses. Any trademark which is identical with or similar to your trademark and designated goods fall into these 5 subclasses will be blocked by your trademark application. However, if someone applies the same mark on hats, which fall into subclass 2508, it will be good for it to be registered, which means although the products are related, but since they belong to different subclasses, according to Chinese examination standard, they are considered dissimilar. So that's the reason when we recommend our client, when they file trademark application in China, they need to occupy as many subclasses as possible so as to obtain a broader protection scope.
But that's only in the face of not having any other similar marks already on the register in that class kind of thing, right?
Yeah.
So if we have a client who, wants to register bootstraps under class 25, I guess, and there's shoes. I mean, is there a benefit for them if there's already someone covering that bootstraps for them to identify other clothing articles that are similar to that in a different subclassification in order to gain registration? Is that how people overcome this, or?
Because in China, we don't have a separate registration system for defensive trademark. So such as your products is boots, and you it belongs to subclass 2507.
Okay.
So it doesn't cover like clothing, shirts, or pants in the other subclasses, but the products are highly related. And in the mall, it's very common that some brands, they sell both boots and pants or clothes. So it's very important to also register trademark in subclasses covering clothing or hats. If you don't have such kind of registration or application, you cannot block others' trademark application, even for the identical trademark.
Okay, so I'm not sure if I'm following entirely, but that's because that's why we hire people like you to be able to assist us over in China. If you're incapable of getting registration because a subclass is blocking your primary goods, do you ever recommend that they still seek registration in other subclasses in order to be able to sell goods in China?
Yes,
Okay.
because it's not for the purpose of only selling products in China. It's for the protection purpose, I think, because there are so many bad faith applications in China, especially during the recent years. If you don't have a well protected trademark, then you will need to enforce your trademark from time to time, which is time and money consuming. Because such as if you have very famous boots and you only register your trademark on boots, you don't know whether there will be someone apply the same mark on clothing or
Or belts
hats.
or something. Yeah.
Yeah, and then yeah, it's a problem. You will need to trying to canceling the mark or oppose the mark, and um, it's not definite that the cancellation or opposition will be successful.
Okay.
Mhm.
So just going back to my question about what the examiners are looking for. So they're looking to make sure that the goods or services are identified in the proper classes and subclasses, and
Mhm.
that they're not confusing with other marks already on the register in those classes or subclasses,
Mhm.
and that they're distinctive based on what criteria is the distinctiveness? Is it based on what the Chinese translation would be, or what the mark is, or how are they basing that distinctiveness other than being recognized by Chinese purchasers?
Distinctiveness, according to Chinese standard, it can help the consumers to um, recognize the origin of the products,
Okay.
which means the trademark can tell you the origin rather than a characteristic of the products. For example, Apple in computer is distinctiveness. It's distinctive because the product has no relation with the trademark. And when you see a computer named Apple, you know where it is from. But if you see an apple, a real apple, and its trademark is Apple, you don't know which.
Yeah, exactly. You don't know where it came.
Yeah, yeah. So
Okay,
yeah.
so that makes sense. So the subclassification system is based on breaking each class down into, are they like groups kind of things?
Yes,
So maybe you can
yes.
elaborate
Small
a little
groups.
bit more on that. So I mean, for instance, in class 28 for
Mhm.
toys, how many subclasses are there? Are there like hundreds or something?
I need to check. We have we have a very basic book, which is the Chinese classification table for similar goods, and it revises from year to year.
Okay,
Every year we have a new edition.
great.
Mhm.
Okay, so let's go back to the registration process. What's the average time from filing through to registration in China?
Currently, it may take around 1 year. At the most fastest speed, I think it may take around 8 to 9 months.
Wow, that is good. I've never experienced that in China, and we're certainly not experiencing that in Canada right now. We're looking at close to, for Canadian nationals, it's close to 3 or 4 years to get registration now. It can be as high
Mhm.
as five
Mhm.
if you have to go through the application, the acquired distinctiveness route, because we're now examining for not inherently distinctiveness. So it's just taking forever. How long is a registration valid for in China?
10 years.
10 years. So that's similar to
Mhm.
Canada. When you
Mhm.
file in China or in Beijing, does it cover Hong Kong, or are they separate offices altogether now?
Separate.
Separate.
Hong Kong, Macau, they all are special administration area in China. So they still keep their special IP registration system. Trademark registration in mainland China is only valid in mainland. If
Okay.
you want to protect your trademark in Hong Kong, Macau, and Taiwan, a separate trademark application need to be filed with local trademark office.
Okay. And your offices, do they cover all of those jurisdictions?
Yes, yes, we can handle those cases.
Perfect. Okay. Do you
Yeah.
require use in China to get registration?
For getting registration is not required, and for renewal is not required. But after our trademark is registered for more than 3 years, it's vulnerable to non-use cancellations.
Same in
So it
Canada.
may be, attacked by non-use cancellations.
Okay. And does that happen quite frequently? Do people get registration and never use it?
Yes. In recent years, because the Chinese registration, trademark registration, so there are so many Chinese registrations in China, and it's getting difficult and more difficult to register a trademark in China. So non-use cancellation become cost-effective weapon
Yeah.
to swipe down prior registrations.
Okay. Do you use the term trademark squatters at all in China?
Yes, yes,
Uh,
use that.
we've had a number of them. So just before Canada changed the legislation in 2019, we had a
Mm-hmm,
slew of companies. A lot of them came from the UK
mm-hmm,
that were filing in every class possible for generic words, and we called them trademark squatters. They are just a pain, but I think the office is onto them now, so they're clearing out a lot of those ones. So are there any marking laws in China? And by that I mean, can you use the TM? Is the TM symbol a universal symbol that you use in China?
Yeah, you can use that.
And
Um,
can you use it at any time, or do you have to have an application filed before the CNIPA?
You can use it anytime
Okay.
because it tells people it's a trademark. You
Yeah,
use
you're
it
using
as
it
a
as a
trademark.
trademark,
Yeah,
right?
you are using a trademark.
Okay. And do you have to you mark your registered trademarks with the R symbol, the registration symbol?
You can mark is it. You can mark with it. You can either not to mark with it. It's up to you.
Okay, so
It's
no
up to you.
marking laws. It's exactly
Mm-hmm.
the same as in Canada. But
Mm-hmm.
it's always a benefit to give public notice that you're using it as a trademark, using the TM symbol, or
Mm-hmm.
that you're using, once you've got achieved registration, that you use the registration symbol.
Mm-hmm.
So, what's the overall cost of a trademark registration in China?
And if for a smooth application from filing to registration for one mark in the first class, it should be less than 500 US dollars. And
But
for
do
the
they ever
second,
make it through?
yeah, make it through.
Because I mean, we've had clients say that, not clients, associates tell us it's
Mhm,
around 500 US dollars from application
mhm.
through to registration, but inevitably
Uh,
you get a refusal because of subclassification differences or those kind of things.
uh-huh,
So it ends up being a little more expensive than that.
uh-huh.
So
For us,
assuming that there's going to be
mhm.
a little bit of complication, what do you think is the average cost of an application in China?
Maybe if don't consider the provisional refusal issue, I think it may be less than 1,000 US
Okay,
dollar.
but if
Yeah,
you get a
because
provisional refusal,
um, it can be another 1,000 US dollar.
okay, so that makes sense.
Mhm,
And then the renewal every 10 years, is
mhm.
that like a simple process, or does it go through an examination process again, or do you have to prove use of your mark in China to get renewal?
It's it goes examination, but not that complicated. Only formality examination. and you don't need to prove the use of the mark,
Okay.
which means you just fill in the application form
Yeah.
and submit the required documents like your certificate of incorporation,
Okay.
power of attorney. Then the renewal will be examined and approved.
Okay. And finally, one final question. Why do you recommend registration in China for any foreign clients?
Because we have the largest population in the world, and we have one of the largest markets in the world. The market is very important. And China is a first file jurisdiction. So
Well, see,
it's always,
that makes sense. Yeah. So
yeah.
Canada is a first to use jurisdiction, but we're leaning more towards the first to file, because
Mhm.
if you even if you have use first, if someone else files it and you don't oppose it or do any of that kind of stuff, you may lose some of your rights or some of your jurisdiction for sales. Lena, it's been an absolute honor to have you join me on today's IP Somm and talk about the differences between the Chinese and the Canadian application process. If you like what you
Thank you.
saw here, please like, share, comment below, and subscribe to our YouTube channel. Remember, we're not providing legal advice here. We're just sipping on our teas and infusions today and talking IP. Cheers.